Lucy, shall we start? Are we ready? Okay, perfect. So I believe you're able to hear me. I'm very happy to be here. My name is Alessandro Di Maiuta. For those that do not know me, sorry, I'm the Director General for Associazioni Diplomatici. I would like to quickly open this webinar for this afternoon, thanking really from both personally and also on behalf of entire Associazioni Diplomatici, Professor Agnello Merone, who has been the contact point, the mind behind this partnership. This is the second webinar that we organize with Università Europea di Roma. And we are very happy to give this opportunity to the students that are going to be participating in 2 weeks' time in our New York City conference. The theme is very interesting, especially for the developments that in these days we just had. And I am very honored and humbled of this partnership. We are going to do incredible things with Università Europea. Maybe we're going to host partially an event within Università Europea. It's a long-lasting relationship with the university and Professor Merone. Before passing on the floor to our chair and moderator, journalist Mattia Ferraresi, I wanted to tell obviously the students that are watching this webinar this afternoon that Professor Merone will be in New York City with us. You might meet him throughout the corridors of the Marriott Marquis or at the United Nations headquarters. And should you want to hear more about Università Europea, should you want to hear more about the possibilities of coming and studying here in Rome, I'm based also in Rome, please do so. So without any further ado, thank you very much, everyone. And I leave the floor to Mattia Ferraresi.
Thank you so much, Alessandro, for your kind introduction, and thank you for hosting this event to Associazioni Diplomatici and the Università Europea di Roma. Thanks for having me and for giving me the privilege to be the moderator of this, for sure, interesting discussion that comes, obviously, as you may know, as it's obvious to everyone, like a few weeks after the first anniversary of the disgraceful invasion of Ukraine by the Russian forces. Let me introduce myself. My name is Mattia Ferraresi. I am the managing editor of the Italian newspaper Domani, and where I also edit a monthly supplement called Scenari, which deals with geopolitical issues and foreign affairs. So it is my pleasure to introduce this discussion, and I don't want to waste your time more than this, because there's going to be a lot of interesting remarks and hopefully some back and forths. First, a little bit of housekeeping rules. You are more than welcome to write down your questions you may have while you follow the seminar, while you watching the remarks on the chat, so I will be able to check it out and select and summarize them and to offer them to our guests. And let me just tell you this, that as I said, of course, a year ago, something absolutely incredible in many ways happened, catching pretty much the world as a surprise, and surprising many observers that did not predict what happened. And a year later, I have to say, and this is like, I think, a good starting point to introduce our conversation, we are in a pretty much an uncharted territory, in the sense that what observer and what actors involved in this war did not plan for sure what we are seeing now, which is clearly a scenario in which all actors involved are preparing for a conflict that is dragging on and is going to be, at least according to the major players involved, more like medium to long term conflict in forms that we, of course, don't know yet. But for sure, we are unfortunately celebrating a terrible anniversary that we didn't expect, because the calculations and were very much different, and the odds were like on a different side 1 year ago. So with that in mind, and I really wanna hear what our guests have to say about the perspective, not just what's happening on the ground today, but the perspective and the likeliest scenarios that are in front of us. I'm gonna introduce them, and unfortunately, we had a little bit of an issue with one of our speakers. Unfortunately, Professor Fiammetta Borgia was supposed to speak today. She is a bit under the weather, so she could not be with us today. But she recommended a colleague of hers, a researcher that she's here with us, Adelaide Luminari, doctoral researcher at the Università Europea di Roma. Her remarks will focus on the invasion of Ukraine and the concept of aggression in international law. And I'm going to introduce the other two guests as well. Professor Aniello Merone, Associate Professor of Civil Procedural Law, also at the Università Europea di Roma. He will talk about the effects of the European Parliament's declaration that claims Russia as a sponsor state of terrorism. And last but not least, Professor Guido Traficante, Associate Professor of Economic Policy at the Università Europea di Roma. He will deal with the economic effects of war, and I'm sure we're gonna hear a lot about sanctions, which is, of course, one of the major topic of conversation in this last year, and a major topic of conversation to understand how the war will develop in the future, and what's going to be the next chapter. For sure, this is incredibly important to give that assessment. So I'm happy to leave the floor to Adelaide Luminari for her initial remarks, and I remind you that you can put your question you may have on our common chat, and I'll take care of it once the remarks are over. Thank you, Adelaide. Thank you, everybody.
Thank you very much, Mr. Mattia Ferraresi. And so today we're going to talk about the invasion of Ukraine and the concept of aggression in international law. So first of all, we can say that Russia's invasion of Ukraine violated the prohibition of force contained in the United Nations Charter and the peremptory norm of general international law prohibiting aggression. In fact, the invasion was not an exercise of individual or collective self-defense or humanitarian intervention, as Russia variously claimed. The United Nations General Assembly rejected all such claims when 141 members of the General Assembly voted to deplore in the strongest terms the aggression by the Russian Federation against Ukraine in violation of Article 2.4 of the Charter, as well as the involvement of Belarus in this unlawful use of force against Ukraine. First of all, we are going, please, if you can change the slide, thank you, because I do not have, thank you very much. So first of all, we are going to talk about the definition of aggression. On the 14th of December of 1974, the General Assembly adopted by consensus Resolution 3314, annexing the definition of aggression, which had been adopted by the Fourth Special Committee. Next slide, please. And the definition begins with a broad definition of aggression, drawn largely from Article 2, Paragraph 4 of the Charter, and then enumerates specific examples of acts of aggression. The acts set out in Article 3 qualify as acts of aggression, subject to the provisions of Article 2, which envisage that the Security Council may decide not to make a determination of aggression in the light of the circumstances, including the fact that the acts are not of sufficient gravity. Article 4 specifies that the list is not exhaustive and that the Security Council might determine that other acts constitute aggression. The issue of self-determination was a live one during the negotiations, and it was dealt with in a saving clause in Article 7. So the definition is that in an invasion of a state by the armed forces of another state, with or without occupation of the territory, heads the list of aggressive acts set out in Article 3. And the other acts listed, of the other acts that are listed, a few problems that arose in the negotiations may be mentioned. For example, the reference to port blockade in paragraph C gave rise to demands from landlocked states that blockade should include denial or access to end from sea, a problem that was resolved, not to the satisfaction of all, by including a note in the Sixth Committee's report to the General Assembly that the definition did not justify a state in blocking access routes to the sea for landlocked countries. And concerns were also expressed that the reference in paragraph D to attacks also on marine fleets would include as aggression activities by coastal states to preserve fish stocks or the environment. And paragraph G, for example, relating to irregular bands or mercenaries going from one state into another, constitute one of the major difficulties in reaching consensus on the definition. Agreement was then finally reached by narrowing earlier proposals to limit the text to sending organized groups rather than organizing and supporting them. Now, after defining the prohibition of aggression, we can say that Russia's act of aggression is the sum of all the acts of violence carried out by its armed forces against Ukraine and its people. When Russian forces attack civilians, their homes, and business, their hospitals and cultural sites, these attacks are illegal twice over. These attacks violate both the prohibition of aggression and the basic rules of international humanitarian law. Russia incurs state's responsibility for all the damage caused by its internationally wrongful act of aggression. As a matter of principle, states must make full reparation for all injuries directly caused by the unlawful use of force, whether or not these injuries result from violation of international humanitarian law. Under international criminal law, Russian forces appear to have committed war crimes on a large scale as part of a plan or policy that fall within the jurisdiction of the International Criminal Court. Next slide, please. And these apparent war crimes include, but are not limited to, willful killing and causing serious injuries to civilians, torture, deportation, taking hostages, attacking civilians and civilian objects, pillage, rape, and starvation. The manifest of unlawfulness of these crimes precludes any defense that the perpetrators were just following orders from their superiors. Individual criminal responsibility for war crimes extends beyond those who commit them or order their commission to those military commanders who know or should know that such crimes will be committed and fail to take necessary and reasonable measures to prevent them. In principle, criminal responsibility extends all the way up the chain of command to the Supreme Commander-in-Chief of the Armed Forces of the Russian Federation, Vladimir Putin. Individual criminal responsibility for the crime of aggression lies not with ordinary soldiers, but with Russia's political and military leaders who planned, prepared, initiated or executed the invasion, occupation, bombardment, and blockade of Ukraine. And under the current terms of its statute, the International Criminal Court may not exercise jurisdiction over the crime of aggression committed in Ukraine without Russia's consent, which Russia, of course, will not give, or a Security Council referral, which Russia will, of course, veto. So accordingly, states parties to the Rome Statute should amend it to permit the court to exercise jurisdiction over the crime of aggression if the General Assembly, and acting under the Uniting for Peace framework, refers a situation to the prosecutor in which aggression appears to have been committed. This could be done by modifying Articles 13 and 15th of the statute, or by introducing a new article, which could be really difficult. The alternative proposal is the one of creating an ad hoc tribunal. And in relation to human rights, please, next slide, thank you. And every person Russia kills in violation of international humanitarian law, it also kills in violation of that person's human rights to life. So such killings deprive those killed of their lives arbitrarily in violation of legal rules that exist to protect their lives. Such killings also violate the European Convention on Human Rights, which remains binding on Russia. The convention prohibits intentional deprivations of life with narrow exceptions. In time of war, states may take measures derogating from their obligation under the convention. However, no derogation from the convention is permitted with respect to the right to life, except in respect of deaths resulting from lawful acts of war, that is, from acts governed but not prohibited by international humanitarian law. Put the other way around, no derogation is permitted in respect of unlawful acts of war, which violate international humanitarian law. Such unlawful acts of war violate both international humanitarian law and the human rights of those they kill. So every person Russia kills in furtherance of its war of aggression, it also kills in violation of that person's human right to life. All such killings also violate the European Convention on Human Rights. In fact, in time of war, states may take measures derogating from their obligations under the convention only if such measures are not inconsistent with their obligations under international law. Plainly, armed aggression is inconsistent with other obligations under international law. It follows that states may not derogate from their human rights obligations in order to carry out armed aggressions. So in relation to the legal consequences, please next slide, thank you. And Russia's violations of the peremptory norms prohibiting aggression and reflecting the basic rules of international humanitarian law triggered a number of legal consequences that continue to shape the strategic, political, and military landscape. Russia's armed aggression activated Ukraine's right of individual self-defense, and with it, the right of any state in the world to fight alongside Ukraine in collective self-defense at Ukraine's request. Every state in the world is legally obligated not just its Russia's aggression, not to recognize as lawful any situation arising from Russia's aggression, and to cooperate to bring Russia's aggression to an end through lawful means, of course. And the military assistance offered to Ukraine and the economic sanctions imposed on Russia reflect these legal rights and obligations. All states may take countermeasures against Russia because the peremptory norm prohibiting aggressions gives rise to obligations owed to the international community as a whole. Such obligations are erga omnes, in which all states have a legal interest. All states may invoke Russia's responsibility, and all states must take countermeasures against Russia to the extent required by a cooperative actor to bring Russia's aggression to an end. These legal consequences follow directly from Russia's act of aggression and the rules of international law. So this is how international law imposes military and economic costs on aggressors while denying them political benefits. In conclusion, we can say that the place of war in the system of international law has undergone a fundamental change. In fact, aggressive war has ceased to be a sovereign right and has become an unlawful and criminal as well as an immoral act. Yet, the legal consequences of this fundamental change are not all expressly stated in treaty text or United Nations resolutions. Their identification, in fact, we can say in conclusion that requires the reasonable application of legal principles guided by the axiom that international law is a coherent legal system rather than a mere set of rules. So Thank you very much for your attention.
Thank you so much, Adelaide. Thank you for your remarks. While I do remind you that you can write down your question you may have on our chat, and we will share among us, because I do have a question. So I take my privilege as a moderator very seriously. And so I want to ask you something more about a different level in which the legal implication might be understood, which is the genocide thing. Of course, we do remember that last year, it was in April, if I remember correctly. So we were at that point discovering the really worst horrors and the worst massacres committed by Russian forces, especially in Bucha. That was like the first of many, unfortunately, of many such discoveries of horrors. And President Zelensky called it openly a genocide. And I do remember even the US President Joe Biden using that term, of course, without any specific legal implication in that context, but generically calling that a genocide. I wonder if you can drive us a little bit in this idea, whether that might, calling it genocide and making it a genocide as a sort of legal basis to frame what's happening here, if it's possible, and in case, what would be the consequences of such a major step in sort of framing those crimes that, as you described it, are crimes that are recognized by international law that triggers obligations, but for sure the genocide level would bring it to a different to a new level. Can you elaborate on that a little bit?
Yeah, of course. If we try to consider what is happening in Ukraine as genocide, of course, all the legal framework can change, because we can say that the International Criminal Court has his jurisdiction upon international crimes such as genocide, of course, and it would be it would become a crime that the ICC can rule upon. But of course, this even if we can say that what is happening in Ukraine is genocide, it's difficult that this crime can be perpetrated under the ICC, because, of course, as I said in the introduction of the speech, if Russia did not sign the statute of the International Criminal Court, so it's difficult for the ICC to rule upon these crimes, and that's why everybody is talking about making an ad hoc tribunal in order, of course, to be capable of perpetrating these crimes, such as genocide and all the others international crimes committed by individuals, in this case, of course, by Vladimir Putin and its officers in the war. So, yeah, even if we can say that what is happening is genocide, I think that it cannot only be perpetrated if we establish an ad hoc tribunal in order to do so, as happened, for example, with the Tribunal of ex-Yugoslavia and all these kinds of tribunals. For example, the Tribunal of Rwanda, which is the maximum exposition of the crime of genocide, and how it was, of course, taken into consideration in that occasion. So, yeah, I think it's important to do that. Yeah.
Thank you so much. Let me ask you another question from our viewers, then we move to the next speaker. But since you are at it, one of our guests, one of our viewers, it's anonymous, is asking what Switzerland can do as a member of the Security Council, but being a neutral country, of course, a non-permanent member of the Security Council, is asking about that relationship between the neutrality and whether can be an actor in that respect.
So yes, Another important point is that the ICC can also be called upon by the Security Council if there is a decision by it. In this case, of course, there is a problem with the Security Councils because all the decisions that are binding for states taken by the Security Councils can be taken only with the unanimity of the 5 permanent members of the Council. So even if Switzerland now is neutral, yes, or even if it's not, actually it cannot do a lot to bring a binding decision from the Security Council because what's important and that is that the 5 permanent members of the Council votes unanimously. So in this case, we cannot, for example, use the ICC and its jurisdiction upon international crimes if Russia puts its veto on the Security Council resolutions. So in relation to Switzerland in this case, its neutrality, actually, I don't think it can help a lot. What we must focus upon is the 5 permanent members, and maybe what's important is to finally bring how can I say we can bring a reform of the Security Council, which a lot of people talked about during the years, and it's nothing new. But I think that what is happening in Ukraine is also telling us that the United Nations should change their system in relation to the Security Council in order to take more binding and resolutions in the international community. So,
thank you so much. I think really the reform of the Security Council is one of those never-ending issues that every time is sort of like responding to historical circumstances. Everybody's like, okay, this time is going to be different, and then, I mean, nothing happened or not much happens. I mean, I don't want to be sounding too much pessimistic about it, but it is true. This goes in cycles as a conversation. So let me switch to and get our second speakers involved. Professor Agnello Merone, as I said, Professor of Civil Procedural Law at the Università Europea di Roma. Welcome, Agnello, and you're going to talk to us about the effects of the declaration by the European Parliament, claiming that Russia is a sponsor of terrorism. And I'm really eager to understand what are the implications of that declaration. So the floor is yours, Agnello. Thank you so much.
For interesting me, and thank you also to Adelaide that in some ways prepared the ground for my intervention, because as you mentioned, I will try to explain the effects of such resolution taken from the European Parliament on November 2023, adopted with a large majority, close to 80%, that includes Russia as a state sponsor of terrorism. So a state that uses terrorist means in its international relations. Obviously, the reason for this resolution are to be found in the atrocities committed in the Ukraine war scenario, with specific reference to the deliberate attacks and barbarities perpetrated against civilians, the attacks on Ukraine civilian, not military infrastructure, and the violation of the law of war provided by Geneva Convention, distinctive as a serious violation of international and humanitarian law. So it's important to understand that such resolution does not stand alone. It follows previous resolution on the violation of human rights taken before and after the outbreak of the war. And it shows a clear desire to increasingly isolate Russia on the international scenario, especially within multilateral bodies such as the UN Security Council that you mentioned a few seconds before. So in order to justify the adoption of the resolution, the European Parliament focused not only the few arguments that I already mentioned, but also gave wide emphasis to the need of include within the sponsor of terrorism also the paramilitary Wagner group, mercenaries supported by the Russian Ministry of Defense and which has already committed atrocity against civilians in the past, as happened in Second Secession War, in the war of 2008 between Russia and Georgia, in Syrian civil war, in Libya, in Mali. And also they want to condemn the Putin regime for its founding of terrorist regimes and organizations, such as the Assad regime in Syria, to which Russia apparently supplied weapons, and in defense of which it launched deliberate attacks against the Syrian population, and also to stopped the Russian Federation support for the Lukashenko regime in Belarus. On this subject, great prominence was given to the recent hijacking of Ryanair passenger flights to arrest Belarusian dissidents. Such hijacking has been carried out with the collaboration of the Russian secret services, and as you already know, an hijacking of a civilian aircraft constitutes by itself an act of terrorism. So, looking at the effect of such a declaration, is really important to clarify that European Parliament resolution does not have a legislative nature. Therefore, it has a value of political address and is not directly binding for and on the subject to which is delivered. So the European institution, European Council, European Union Council, European Parliament, and the member states do not receive any immediate obligation that arise from the resolution. But as already mentioned, such resolution is an act of extreme political relevance, whose authority is also expressed through the very large majority by which it has been approved. And with its parliaments, European parliaments, formally ask to European Union and its member states to create an appropriate legal framework and consider adding Russia to a list of states sponsoring terrorism. So, in other words, the European Parliament resolution by itself denounces the absence of the necessary legal framework to add Russia to a list of countries sponsoring terrorism, and at the same time highlights the needs for the European institution and the member states of introducing the required legal instrument to achieve an effective ban of Russia. Given those premises and considering the fact that in concrete such resolution translate its political value into a request to the European institution and member states to isolate Russia on international scenario and accelerate council decision on a sanction. But the question that we need to address is, what does it mean to declare a state as a sponsor of terrorism? Such question comes out from the fact that there are some states, a clear minority, that provide by law the possibility of declaring other states as sponsor of terrorism. The most prominent example is the USA, which has Syria, Iran, North Korea, and Cuba on its list. Also, Canada has placed Syria and Iran on its list. And in Europe, we have the example of Lithuania, Estonia, Latvia, and Poland that have already adopted a parliamentary resolution in order to designate Russia as a sponsor of terrorism. But the question that we want to address still remain: what are the practical effects of this provision? In concrete, what is its function? The main function is to strengthen the protection of the victims of terrorist acts committed or believed to have been committed by states labeled as sponsor of terrorism. And what does it mean, or if you prefer, how this protection will be strengthened? The answer is by allowing victims to take legal action against state sponsor of terrorism before the courts of their own states that have put, for instance, Russia on the list, in order to offering to those victims the concrete possibility to ask for their protection, to seek a determination of state responsibility and receive a compensation for damages. In the legal system of United States and Canada, United States of America, of course, and Canada, it is expressly provided that the definition of the state as sponsor of terrorism allows for an exception to the rules that guarantees state immunity from the jurisdiction of other states. This rule is one of the oldest principles that we have in international law, and if I may, a cornerstone of international procedural law. Is expressly by an old Latin brocardo, par imparem non habet jurisdictionem. So by virtue of this principle, a state cannot be sued before a foreign judge, foreign court, for instance, also the Italian judge, to answer of an act performed iure imperi, for an activity that fall within the scope of state sovereignty. This very old principle, in the past, at the origin of international law, as considered as absolute. So all the states receive from the international law an absolute jurisdictional immunity in the relationship between them. And we have a sentence, a judgment from the United States Supreme Court, the Schooner Exchange versus McFadden, that has been dated 1812, that's confirm the absolute character of such jurisdictional immunity. But during the 19th century, when the state began to be extensively involved in commercial activities, several states start to feel the exigence to introduce some limits to this absolute immunity. And was the Italian and Belgian courts that were the first to argue that immunity was intended to protect only the sovereign function of the states, what we used to call acta iure imperi, and not the activities carried out by the states when they act as a private subject, what we used to call acta iure gestionis or acta iure privatorum. So nowadays, the majority of the states, the court of the majority of the states, have gradually conformed to this more restrictive interpretation. Consequently, the rule of international law that we used to apply recognize jurisdictional immunity as restricted to sovereign acts only to the acta iure imperi. Which are the consequences of such principle? What does it mean that we cannot act against a state for acta iure imperi, or better, that the state can use this jurisdictional immunity? If an Italian citizen, to make you an example, brings a civil action against a foreign state that has committed acts, even if such acts are illegal, but carried out in the exercise of its own sovereignty, the claim cannot be brought before an Italian court, an Italian judge. Indeed, such claim should be brought before the courts of the state to which the illegal act is ascribed. And at the same time, all the assets that a foreign state used in sovereign activities or intended to public function, for instance, embassies, cannot be subjected to executive or precautionary measures. If you look at a situation like the one that is well described by Adelaide, and so all the violation of international law suffered by Ukrainian people at the moment, we talk, taking by random words of President Biden, not of genocides, we have to imagine that in such specific situation, such people, in theory, in order to receive protection of their own rights, needs to start a suit in front of Russian courts. On the contrary, if we allow for an exception that guarantees state immunity from the jurisdiction of other states, we put on the table the possibility for the victim of such acts, included terrorist acts, will not be forced to take legal action before the courts of the states who committed those acts, clearly in contrast to international and humanitarian law, but they will be able to sue the foreign states before the courts of their own country. The same that happened in United States and Canada, because it's concretely previewed by the law. And it usually highlights, for your proper comprehension, that the reference of all my speech is to so-called functional immunity and not to personal immunity, the one mentioned before by Adelaide Luminari, that, for instance, can bring in the future Putin or one of his generals in front of an international criminal court. So these topics that I addressed to you is, as mentioned, one of the classic topic of international procedural law, and is at the same time a matter regulated in detail by a United Nations Convention. It's a United Nations Convention adopted in 2004 and specifically dedicated to the jurisdictional immunities of states and their property. It's also interesting notice that an early attempt has been made by European Union. We have an European Convention on the Immunity of States adopted by Council of Europe in 1972 and entered into force in 1976, but ratified by only 8 states. So we cannot refer to this convention as a success. But I want to mention, because clearly explain to you how is delicate, this aspect to manage. And both the convention that I mentioned do not adopt the distinction between acta iure imperi and acta iure gestionis. They both adopt the so-called list method. So they list a series of activities, mainly commercial, for which the state cannot invoke jurisdictional immunity. Nevertheless, such a distinction between acta iure imperi and acta iure gestionis remains pivotal, remains crucial, because for those countries that have not adopted domestic legislation on this topic, foreign state immunity, they have to decide it case by case, interpreting the international law criteria. So when we look at this topic, there is another very important issue that remains real actual if we look at the present situation in Ukraine. The most debated issue in recent years and subject of a dispute between Italy and other European country from one side and the Federal Republic of Germany on the other sides can be summarized as follows. Is the rule on immunity from jurisdiction applicable when a state has committed serious violation of mandatory rules, in particular provision protecting fundamental human rights? We used to call all the norms, all the provision that protects fundamental human rights as jus cogens. And the Italian Supreme Court, Italian Corte di Cassazione, with a judgment in 2004, issued on the Ferrini case and then confirmed in a series of subsequent decisions, denied Germany immunity from jurisdiction for war crimes committed during the Second World War, arguing that immunity could not be applied to unlawful acts that violated fundamental human rights and then constitute a violation of mandatory provision, so-called jus cogens. So such need to deny immunity for jurisdiction has been recognized also by other states, as I mentioned, Greek Supreme Court, United States Supreme Court, but, for instance, had been resolutely denied by the British House of Lords, which consider Italian jurisprudence inconsistent with current customary international law. It is important to try to understand how we introduce such exception to jurisdictional immunity and how we can justify it. There are several theory, but the predominant one is the one based on the hierarchical superiority of the rules of jus cogens, which would allow an exception to the application of the rules of immunity. And this is the approach followed by the Italian Supreme Court. That's also enlarge the reasonment and argue that jus cogens prevails over the rules of the jurisdictional immunity, also in order of ensuring an appropriate balancing of values and preventing victims from being deprived of their rights to access to justice and to be restored. Because otherwise, if I oblige victims to go in front of the courts of the states that committed acts of terrorism, that commit acts of genocide, that commit acts that violate humanitarian law, in concrete, I cannot give any hope to be restored. and I have to offer to them some alternative remedies. Such theory, and I quite close to conclude because I also know that this argument sounds a little bit technical. Such approach, such thesis, at the same time was contested by the International Court of Justice in several judgments. The first of them has been dated 2012. The International Court of Justice condemned the approach taken by the Italian courts, and they held Italy liable for having violated the rule on the immunity of state from jurisdiction. According to the approach taken by International Court of Justice, the rule providing for jurisdictional immunity is also applicable when the acta iure imperi constitute a serious violation of human rights and international humanitarian law. Why? Because from their point of view, there is no conflict, no hierarchical relationship between rule of substantive nature, such as those prohibiting international crimes, and rules of procedural nature, such as the ones that providing immunity from jurisdiction of other states. So for International Court of Justice, we are talking of rules that cover different aspects. They are on the different level, and so it's not possible to see a conflict between them. And at the same time, the International Court of Justice formally affirmed that international law grants immunity to other state jurisdiction also for offense committed in the territory of the other states by armed forces or other organ during armed conflict. So this is very close to what is happening nowadays in Ukraine, and so we can still and already see to the position already taken by a very important international court. At the same time, the International Criminal Court regrets for the lack of alternative remedies for victims, but consider that such circumstance has no impact on the application on the immunity rule. So, as you can see, the step moved by the European Parliament is a very important one, because notwithstanding the fact that is not a compulsory act, is an act that has no legislative value, the European Parliament formally asked to the European state member to start in working in order to create a legal framework that allow to put a state on such list in order to make an exception to the jurisdictional immunity. And this final goal, maybe we can see in some years, I don't want to predict how many years we need to reach this goal, but such goal brings to my mind a sentence that is can be taken from another United States Supreme Court decision, McNabb versus United States, is a sentence that my master, Professor Picardi, used to mention. The history of freedom has largely been the history of respect for procedural rights. Why is important this sentence? Because it reminds us that when someone recognizes to you a right, also when we are talking about the most brutal crimes that needs to be condemned, and we of course feel the necessity to protect the right of the victims, such rights always needs a procedural mechanism that grants to us the possibility to give them the protection required. Otherwise, the recognition, the formal recognition of rights risk to be something that remain as a word on a page, because we are not capable to act, to suit in front on a tribunal, in front of on a court, asking for the protection and the recognition of such rights. So I hope that this brief speech give to you an idea of the importance of the topic we are facing, notwithstanding the fact that for the moment is only a politically address that we receive from European Union. Thank you for your attention.
Thank you so much, Aniello. And we got like a few questions, and one of which relates exactly to what you just said right now about the sort of like consequences and the possible other legal action in addition to what amounts to a political statement, as you said, and a pretty significant one. So one of our viewers here asked, what will be the future and concrete legal actions against Russia by the EU Parliament or others? So if you may make us understand if there are additional legal pathways to reinforce the case against Russia as a state sponsor of terrorism. And while you think about the answer, I want to address really briefly a couple of other questions that have been asked. And our friend Ignacio Gonzalez asked a couple of questions that are diplomatic questions. I will share some my own observations very briefly, and then turn all those questions to you, because he's asking, the first question he's asking is about the polls between Turkey and China to become mediators of the conflict. So it's a very diplomatic question, which my observation would be, if you do remember last year, at the very beginning of the invasion of the war, Turkey was thought to be like a crucial player in that respect, and there were like a sort of back channels negotiation. There were like kind of some of them even open in public. It did not work, and you know, like I think two factors has to be taken into account when we deal with Turkey. One, the upcoming election, May 14th, are being just called with Erdogan in a very, very complicated yet pretty strong place. The opposition is divided, is not finding a common ground to oppose it. So there is a domestic issue that has to be taken into consideration.
Earthquake that complicates a lot of the
earthquake absolutely complicated everything. And also, I think is always like necessary to remind ourselves that Turkey is a NATO country and is not a founding member, but was added just a few years later after the North Atlantic Alliance was founded, which makes it probably this is my view at least, a complicated position to be like a sort of a neutral mediator, although for sure it wants to be. For China, it's a very interesting moment. I think it's a very timely question, because what we're seeing is very interesting, and I have no answer with that, but just throwing some elements out there in order for us to reflect about it. Let's consider what just happened, normalization between Iran and Saudi Arabia of their diplomatic relationship after 7 years, that was mediated by China, which took a very, very strong role in that and took like ownership of that, of being the broker of that deal, was acknowledged publicly in a way that is not consistent with the traditional China policy, which is one of non-interference. So China rarely or never wanted to be the broker of international negotiation. Is changing its position, definitely. The world order, I mean, is taking a more active position. So it's interesting. And two facts, just yesterday, Wall Street Journal, in a big breaking news, broke the news that President Zelensky. We will talk with Xi quite soon over the phone, and Xi we will visit Moscow later this month or early next month. Very interesting things to consider. Second question, and then I'll go back to Aniello for his question.
If I can, Mattia, because you already answered in a way that absolutely overperform my potential answer. I will also add to support what you say that when some month ago, China started to invite Russia in order to find a way to go out of the conflict and find a negotiation, it was an approach really uncommon. I remember that all the newspaper commented that it was really uncommon that Russia take this type of approach as a mediator of conflicts, and this this approach at the moment, for what I can see, totally disappear. Also because same argument that we spent about Turkey, they have the exigence to be concentrated on internal issue. Also because, as the students certainly know, Xi Jinping received a third mandate, and so they finally close a process very important and crucial for the life of that country. So it's not necessarily this ground, the one that attract the major attention of all the states that we consider as potential mediator of the conflicts.
There is also a second question by the same viewer, Ignacio, is asking how the entrance of Finland, specifically Finland, in NATO, which was approved just a couple of weeks ago in a definitive way, can change the war, which I think is a very interesting question that I asked to everybody. So feel free to intervene or to think about it. But first, Aniello, why don't you go back to the question relating to what the EU can do and will or may do additionally?
I personally think that this legitimate decision taken by Finland make a composition more complex because I certainly know that all the states that are in Finland balcony, all the states that are close, that are really close to Russian, look at this conflict with Ukrainian with a lot of fears and doubts. But at the same time, we know that the main arguments from the Russia side that stand on the back of this conflicts was the idea that NATO doesn't respect the agreement taken at the end of Cold War and when the Berlin Wall falls down. So I think that in this way, we continue to make the NATO presence more prominent, more closer to Russia. And so for the moment, it's not an element that help the negotiation, but maybe is an element that take the negotiation and the diplomatic discussion a step far away.
Thank you so much. Thank you so much for answering a question that, of course, are shared among speakers. So we hopefully will have time to get back to it. But first, I want to introduce the third and last of our speakers today, Professor Guido Trafficante. As I said before, is going to talk us about the economic dimension of the war. And I'm expecting that Professor Trafficante will lead us through understanding better the dynamic of sanctions, which I think is interesting in terms of, from my own perspective as a journalist, as an observer. Last year, this time, the conversation was, of course, about the facts on the ground, but a lot of the conversation was about sanction. Are they effective? Will they work? How far the Western coalition will go in sanctioning Russia? And I think we're seeing something unprecedented, steps that were unprecedented were taken in terms of sanctioning. But still, I think the question is out there, whether are they effective or not, and effective to do what? meaning what's the ultimate goal of sanction? I think there's I think at least I have 1 million questions related to sanction how they work or they don't. So I hope, and I'm sure Professor Trafficante can help us understand better this dimension of the war. The floor is yours.
So first of all, thanks a lot to the organizers for inviting this very interesting discussion. And okay, let me share the screen. I think you see the screen. So, but I would like to start basically from the topic which is related to the question on the entrance of Finland in NATO. So there is in terms of economic consequences of war, there is also this very.
Sorry for interrupt you,
Yes.
but I don't know if the other can hear you really well. Maybe I can suggest you close the camera since you are sharing also the slides. I don't know, is only my problem or also the other.
I share the same problem too.
Yeah, me too.
Okay.
Can you see the screen?
Maybe no. Maybe close the camera because the video is the one that takes the majority of the event, no?
Okay. Thanks for letting me know. So, and I would like to talk about this so-called peace dividend, which is in a way related to the question raised by
I'm afraid Professor Trafficante's connection is not so stable. Maybe I can ask for the help of our host, if they maybe intervene.
Yes, thank you.
Thank you so much.
Mr. Ferraresi. I think it's due to his personal connection. And let's see if there's anything we can do on.
Should I try to address with our other speakers, or while we try to?
Why not? Let's try to.
Why we try to?
I can hear you perfectly, actually.
Can you? Because unfortunately, your voice is breaking up. When we want to try. Why don't we try again for a second time? We'll see if now it works better.
Let's try. So. As I was trying to say, this so-called peace dividend was related of the NATO. So that after the collapse of the Soviet Empire,
I apologize. I apologize, Professor Trafficante. If I'm not the only one hearing you breaking up, I may have to ask whether, if by any chance you may have like a spot with a better reception or like a more stable connection, because unfortunately we cannot follow you like that.
Can you hear me?
Yeah, let's try
Yeah,
again.
we can hear you, but always with this broken voice.
I don't know why the signal here is maximum level. So
actually, right now the last attempt was more promising.
Okay.
Let's try one third time. Then maybe we'll take some questions while we try to fix it.
Okay. So the point is that after the end of Soviet Empire, we observed a reduction in war risks, and this also implies that the governments could use a lower amount of public resources for defense spending. Okay, and as a consequence, if the governments can use a lower amount of public resources for defense, they can use these resources for other scopes, and this is what is called the peace dividend. Now, this peace dividend, which can be observed also in this graph here, okay? In this graph, you can observe what is the amount of public spending dedicated to defense after the Second World War, starting in the Second World War. And you see that these numbers are declining, and they reach the minimum point probably after the end of the Soviet Empire. Now, the fact that we are in a war in this moment put these numbers in discussion, because probably there would be need to increase the expenditure for defense. And this is why the entrance of Finland in NATO, for example, is, in my view, not a good signal in terms of defense spending, because probably we are skeptical if we are able today to face another Cold War period, and in general, if we have enough resources to cope with this tremendous shock in terms of geopolitics and in terms of public spending. Remember that we are arriving at this war after a great financial crisis, after COVID. So we observe economies which were already really suffering after such huge shocks. Okay. So now let me go back to the topic which was launched by Mattia Ferraresi about the effects of sanctions. And clearly, we know that the economic consequences of the war are related to the effects of sanctions on Russia on the one hand, and on the effects of these sanctions on European countries on the other hand. And this is mainly due to Europeans' dependence on Russian energy and the other resources which we import from Russia. So in terms of sanctions to Russia, I won't spend a lot of time on this. We had some financial sanctions, which were access to capital markets, which was made at least more difficult for Russia. There was a ban on transactions with the Russian Central Bank and several Russian banks, including the exclusion from the SWIFT system in terms of financial transactions. And also, we can observe some sanctions that hit the export of commodities, in particular the commodities that we need from Russia, of imports, and other sanctions such as the sanctions on individuals, the oligarchs that have a lot of real estate properties and other objects throughout the European countries, and not only in Europe. Okay? Now, what was the main effect of this sanction, at least for the Russian economy, and the event that was heavily discussed in the economic arena and also in the political arena? So the dynamics of ruble was interesting, because we observed, first of all, depreciation, where this depreciation was triggered by the freeze of foreign reserves, the exclusion of Russia from borrowing markets, the growth of domestic precautionary demand for foreign currency, which depresses the demand for ruble. But very soon we observed also an appreciation of the ruble, which on the other hand was due to the fact that there were some artificial limits which was imposed by the Central Bank of Russia and by the national government with respect to the usage of foreign currencies. Among these, we can mention the presence of taxes on currency conversion, which amounted to about 12% against the euro and the US. So this is why we observe this basically these dynamics in terms of the ruble. We observed that in the beginning the ruble depreciated, but then soon we observed this huge appreciation of the ruble. And someone says, you know what, the ruble is appreciating and the sanctions are not working, which is, in my view, a very, not really true in terms of the effects of sanctions, because basically you are considering with the sanctions a country which is closed to the rest of the world, and the appreciation of the ruble is does not produce a relevant consequence in terms of purchasing power for Russia, because when we observe that currency is appreciating, we say, you know what, okay, this is good, we can purchase I don't know, oil and other commodities at the more favorable conditions because the euro is appreciated. We can afford a larger amount of these commodities, and on the other hand, this is not beneficial in terms of export, right? But when you are in a almost a closed economy, as Russia became after the invasion of Ukraine, the appreciation does not produce any real effects in the end. In fact, in terms of production of goods and services, Russia is completely isolated now. Lots of companies, multinational companies, are not present anymore in the country. So the appreciation is something which matters only for the national accounts, but not, it doesn't produce any real effects in the okay. So this is why we can say that sanctions are not really phasing, in my view, at least for Russia, because the appreciation of the ruble comes at significant costs. One cost is that there is, in a way, exclusion of Russia from the global value chain in international markets. And this was something that was already hard after the COVID-19 crisis. But in the same time, this financial repression is costly for households in Russia, because typically households want to hold the foreign currency as a safe asset, but this is not possible anymore. And so, okay, you hold the currency, the ruble, which it was highly appreciated in the previous months. Now it is on more long-run values, but I mean, even if it is appreciated, it doesn't produce any real effects in the country. Okay? So this is also related to the role of Russia in the global value chain. What is the main, let's say, expertise of Russia, the main contribution of Russia in terms of the global value chain? Of course, the trade of the export of commodities, in particular energy, metals, chemicals, and the largest trade partners are China, Germany, the US, and in general the Euro area. And of course, the presence of sanctions induce some sizable effects also in Western countries, and in particular on the Euro area. Okay? And the transmission channel of these sanctions worked through the price of energy, in particular of gas. Therefore, I will present some evidence on the effects of the war for European countries, starting with the fact that I mean, the most important commodity which is traded by Russia is gas, and gas corresponds to about 45% of imports for the euro area. And let me show first of all the euro area energy dependency ratio. As you can see here, natural gas is the second, but not very distant, contributor to the total dependence of Europe in terms of energy. It is very close to the data with respect to petroleum products, while renewables and nuclear in general, let me focus more on renewables, which are more debated in the discussion. Renewables are completely independent. They do not depend on Russia or other countries. That's why one response after the Russian invasion was to try to strengthen the contribution of renewables in the total, total amount of energy in a country. This is the first thing to observe in terms of the transmission of sanction, we can also have a look at the sectors which are mostly affected by the sanctions. We can see that of course the sanctions on gas affect, for example, the transport sector, industrial sector, but it has also a sizable effect also on services and households needs. Those are the costs that we feel probably closer in terms of what's going on after Russia's invasion. And this is the same analysis when we take into account the industrial sectors which need of energy, and in particular of gas, which was under the objective of these sanctions. So we see that besides the transformation of natural gas in other forms of energy, we observe that other sectors really depend on gas, either in its end use or as end use, or in terms of transformed gas. And these are, for example, the sectors of electricity, gas, steam, and air conditioning supply. Okay. So what were the measures that European countries tried to adopt in the aftermath of this invasion? Besides the sanction, they tried to diversify the sources of energy. One way is the usage of pipelines, which is the most economical way, but they are very price dependent because they depend too much on the distance of the pipeline. There is, on the other hand, the LNG, the liquefied natural gas, which, however, is very expensive. And they try to diversify the number of countries with which they can import gas. For example, the US, Norway, Turkmenistan, other countries in Africa, to reduce the dependence on Russian gas. Clearly, this is not something very easy to obtain, especially in the short run. It takes time to diversify the sources of energy and to reduce the dependence on Russia. But we already see some signals such that the demand is starting to shift. Consumers are considering alternative for gas. The demand for renewable energy will probably rise in the future, also through the intervention of governments and the stimulus in terms of demand and investment in this kind of energy. And just to mention an initiative which was undertaken at the European level, there is the Repower EU Plan and Recovery and Resilience Facility, which goes in the direction of putting together the countries in the euro area with the objective of investing cross-border and local infrastructure and starting energy projects, not only in terms of the national projects, but with the objective of creating a European market. Okay? So, what are the effects of this? Of the fact that we actually have a lower amount of the Russian gas coming from or Russian gas in Europe. There was some estimates. This is some estimates conducted by the European Central Bank, which assumes the following scenario, which is suppose that there is a cut of 10% gas, so gas is rationed by 10% overall in the euro area, and see what is the effect in the countries belonging to the euro area, as well as to the euro area as a whole. And in fact, this yellow rectangle that you see here is the euro area as a whole, and the estimate provided by the European Central Bank is that for each 10% cut in the gas supply coming from Russia, the contraction in GDP amounts to 0.7. Okay? And of course, this average number should be compared with the variability across countries. We see that let's see if we observe Italy has a larger dependence on gas, so the contraction in Italy is larger, even larger than what we can see in terms of GDP. And we have that some countries, such as Slovakia, are the most dependent in terms of gas, probably because they are countries which are the emerging countries in the euro area, so they are in the path of economic growth which Italy experienced after the Second World War. So they rely less on the service sector compared to more mature. Now, the main problem in the euro area, but not only in the euro area, this is a problem which is common also to the US, is inflation. We abruptly arrived to a setup characterized by inflation, while in the previous at least 10 years, we were in a setup characterized instead by deflation or low inflation. But suddenly, after the COVID-19 crisis, we arrived at this inflationary scenario. What is the contribution of gas to or in general of energy products to the spike in inflation that we observed in the last year? This is a very difficult question, which also implies different policy response of policymakers and in particular central bank. But we can see that there is something changing across the years. For example, if you look at 2021, when inflation was lower compared to the last year, we see that the role played by energy prices was largely predominant. It was still predominant in 2022. The energy component is this blue rectangle here. But you observe that already in 2022, food prices were a significant component, a significant driver in the evolution of inflation. And in 2023, the role of energy prices is not the largest one in explaining why inflation is so high, because it is food prices which are the component that matters the most for the evolution of inflation in the economy. Okay? And you can see this also by having a look at the different components of food, distinguishing between I don't know, bread, pasta, flours, and other cereals, to have a look that food is the main component now in the determination of inflation. Okay, and so this is something which is very important to take into account, because of course there is a spillover effect from the energy prices to the food prices. So if energy is more expensive, everything will be more expensive, including food. But probably we can observe that there is a lack of supply, which is not growing at the same pace of the demand side, which is now determining the increase in food prices and in general inflation. And now this is something that must be taken into account also and especially by central bankers. Now, these graphs, I think, are very important to understand what's going on now. Now, in the first panel that you see here, you can observe the gas prices measured in terms of the futures contract for the euro area and the United States. You observe that in the aftermath of the Russian invasion, gas prices reached the maximum level in the euro area. The increase in the US was much lower because the US, as we know, is relies less on Russian gas. But then also because of some policy measures which were taken by policymakers in Europe, you see that the impact was lower. So everyone is now expecting a lower price of gas in the future because of, for example, the effort of national governments to rely less on Russia, the transition to renewables, etc. What happens to the other components of inflation? So you see in this second central panel here, the evolution of some indicators of inflation. We have the harmonized index of consumer prices, which is this green line here. The other lines are other indicators. I don't want to be very specific on these indicators. If you are interested, I can give you the details. But these are some indicators in terms of inflation. So what you see is that there is an upward trend in inflation. The most important element to consider is this one, the green line, the solid green line here, which is the reference inflation rate for central bankers, because this is the harmonized index of consumer prices, excluding tobacco. We have also food, but you are excluding a very volatile item. Okay? So what's this chart shows us is that we have a decoupling in the dynamics of prices from the dynamics of gas. So probably governments were successful in reducing the dependence from Russian gas, but still we have a problem in terms of inflation. That's why now central banks are increasing interest rates. Okay? Of course, this is something which is not without any consequences, because the increasing interest rates is very costly for some reasons. Just to mention one of them, because of the borrowing costs for firms and households. But having inflation is still cost, is also a relevant cost, because under the economic viewpoint, inflation is considered as a tax, and a very unequal tax, because it is a tax which hits much more people who are poorer compared to people who are rich. If you are Bill Gates, you suffer much less from increasing inflation rather than if you are, you know, a teacher or an employee with a fixed salary. And that's why all the central banks try to reduce inflation. The good part is in terms of unemployment rate, which after the spike that we observed for COVID is now on a promising level. So we are not observing any significant consequences for the economy after the Russian okay, over Europe. And the last point was actually my first point in terms of the peace dividend. Let me go back to this point for another comment. And this comment dates back also to what happened just before the Second World War. So probably what we observed after the invasion of Nazis of Czechoslovakia was that everything thought that it was a quarrel in a faraway country between people of whom we know nothing. And this was, with the benefit of hindsight, it was a capital mistake, because this resulted in the Second World War. So probably similar thinking about the Russian invasion would be a tragic repeat of history. And also, as I mentioned before, I'm not sure we are now able to cope again with another Cold War as we had after the Second World War. And therefore, helping Ukraine could be considered under the economic viewpoint as an investment in global security, which can save the so-called peace dividend that I mentioned in the beginning of my talk. Okay. And these are the main references of my presentation. I'm sorry for the technical issues that I had in the first part. I hope the main message at least arrived. And thank you again for the invitation.
After an initial difficulty, Guido, your message arrived, I think, loud and clear to everybody. So that was great. I'm not sure how much time we have, so I'll ask our gracious host, Alessandro, to stop me if I have to conclude, but
we still have 15 minutes more or less.
That's amazing. And I think it's enough. I will ask our speakers to be to summarize, but there are several questions, and I want to try to address some of them. And there is Anastasia Kudliak from our audience. She has two questions. One that relates to what Professor Trafficante Guido just told us, so I will go with that. Could the unilateral sanctions imposed against Russia be considered a violation of the non-intervention principle under international law? I think it's a very important topic, because I think our viewer Anastasia mentioned the fact that maybe there are countries that decide to impose sanctions which are themselves not damaged or harmed directly from Russia's action, which I think opens up the question whether there is a legitimate right to impose sanctions or on the other hand to consider them violations of the international law. And I will give to you in a second, just mentioning another question. So I think Adelaide and Daniello can jump on it. Also from Anastasia, asking about the reform of the UN Security Council. Is it enough, the current situation we're seeing, for understanding there is something wrong with the whole voting procedure in the UN Security Council? Or do you think everything will remain as it is, mainly, if I may rephrase it, I mean, is it the UN Security Council hopeless type of institution that is not able to renew itself even under the most exceptional and extreme circumstances that we are going through. So prepare for that. I'll go back to Guido about the legal basis for international sanctions.
Well, I mean, the point is that what is the alternative to the sanctions? I would face this question by asking, what is the alternative to sanctions? So an alternative to sanction could be a direct military intervention, probably. I don't see other options to try to solve the consequences of this invasion, this war, other than imposing sanctions. And in any case, I think that we should take into account that there will be some consequences. I mean, we already experienced some consequences in terms of the war, what's going on after the war. But everything, we should adopt an approach, let's say, of cost benefits, in the sense that we should evaluate what are the costs of the strategy and the benefits of the strategy. Probably the fact of imposing sanctions in the long run, at least, will produce some long-run benefits for countries. And I think it is the only possibility that we want to use now, especially because probably we were not prepared, at least in the euro area, to a direct intervention. So I don't see other possibility rather than imposing sanction and trying to isolate the country which started the war. So that's the way I would tackle this.
A rather pragmatic and convincing, honestly, case for sanctioning. Adelaide, is the UN Security Council irreformable?
Well, as it is now, I think it is highly unlikely that it will be reformed, just because in order to reform the composition of the Security Council, it's necessary that at least it's necessary the adoption of a vote of at least 2/3 of the members of the General Assembly, the ratification also by at least 2/3 of the members, and including also the Security Council permanent members, so including Russia, China, and all the others permanent members. So in order to reform the Security Council, it's necessary the vote in favor from all the permanent members. So as it is for now, it's really unlikely, just because of this provision. So in order to reform the Security Council, there have been a lot of projects from the General Assembly to reform it. It has been said to do a rotatory phase for to be a permanent member inside the Security Council. So all members of the Security Council can be permanent members on a rotatory basis. But of course, in order to amend the regulate how it is regulated, the Security Council, is necessary the vote from the permanent members. So it's like a circle that does not end ever. So it's really unlikely as it is for now. I think it is.
Thank you so much for the clarification. Aniello, of course, feel free to jump on it as well, but let me also ask you a question that comes from Chiara Rubicondo from our audience, which is related to your area of expertise. So you may have an interesting contribution, I'm sure, about this, which is about the EU enlargement. And of course, there is a big discussion about it, and also a formal invitation to Ukraine has been done. But as Chiara points us, Ukraine at this moment does not fulfill the criteria, the quite strict criteria for access in the EU. But of course, there's a huge political movement to include that because of the significance that would have. But Chiara says, what are the consequences of it if Europe is sort of forcing its own rules for accession, maybe for extremely good reasons, but yet that can have consequences on other members wanting to join, or neighboring countries aspiring to get into the union that could be at that point having their own legitimate reason. Like, I mean, if let me put it like in a way a little bit brutal, if Ukraine got in, even without having the criteria to get in, how can not Georgia, to give you the first and most obvious and most current example to it. So I think that's a question also, one of those, but feel free to go on the Security Council as well if you.
For what concerned the Security Council, the answer given by Adelaide was perfect and clearly explained why we can be quite sure that the Security Council remain as we used to know. And on the other side, we have to consider that in the entire history of the world, we never have been something like United Nations, and so we can be considered a real fortune that we have this institution that in some way grant the possibility for all the states to construct something together and take account of the diplomatic relation constantly. For what concern the question about the Ukraine negotiation for their entrance in the European Union, I think that's honestly the political and social pressure will modify the pathway necessary in order to bring a new member state into European Union. We know that is a process quite large and quite complex. I can imagine that when the conflicts will arrive at the end, one of the topic that will be faced for first will be the entrance of Ukraine in the European Union, but the formal pathway remain inconcrete, very similar to the one that we already know. And there are other countries that are waiting from years, and there are other countries that really aim to get in, and as you mentioned, could be diplomatically and politically very risky, to force the entrance of a particular country. And at the same time, it's not necessarily the entrance of Ukraine in European Union in order to help them in the future reconstruction and to give them the military support as those days demonstrate in concrete, and also to have them in all the necessity that they have to face in the following years. So I think that could be something that still remain on the attention of the public opinion, but the formal and juridical pathway in order to complete the enlargement to such area remain the same, and I think remain quite critical, because as you mentioned, we are not talking about the Croatia or Serbia or Montenegro that are really in the hearts of Europe and well involved in all other political sorry, that is my phone that is ringing. I have to so we cannot make comparison to a country that are in the other area of Europe already involved in the European Union, or already in the process from years, is something that we need to construct from the beginning. So I remain quite convinced that the process will take time, and so will not face something that in a brutal way put Ukraine into European Union.
Thank you so much. So many questions. There's one that I think is particularly fitting for Guido Trafficante, given his area of expertise, and it comes from Daniel Silverstein-Gurvich. I'm sorry if I mispronounced his name. Given that Russia's real GDP is not so high compared to other geopolitical powers, and let me add, for comparison, is significantly lower than Italy's and significantly lower, therefore, from like the major European economies for comparison. Do you think at some point they will have financial difficulties to sustain such a costly armed conflict? And I'm adding to that, at what point? When is the tipping point in which we can sort of estimate that Russia will lack the sort of the significant resources and need in order to continue the military operations?
Yeah, this is a very interesting question, and also a very difficult one, because it's hard to estimate the tipping point and the moment in which the conflict will be not sustainable anymore for Russia. Well, in a way, if you think of the expectations that we had as the war started, probably few people expected that the resistance of Ukraine would be so hard for Russia. So in a way, this is a promising result under our perspective. But in the same time, I think that there is the idea of making this war very, very long for Russians. I don't see that very soon there will be a tipping point, unfortunately, of course. But I think this is what the sanctions try to do. Will try to reduce the economic power of Russia, also in terms of financing the war. But I don't see it would be immediate. It would take time, I think.
Yeah. Thank you so much. I think our time is about to be over, and I do apologize with the other person in the audience. We could not address the questions. So unfortunately, because there were many and extremely interesting, but this gives us the opportunity maybe to create another opportunity like this to address more questions. I do thank you, our speakers, Adelaide Luminari, Aniello Merone, and Guido Trafficante. That was absolutely outstanding and incredibly helpful for understand where we are. Thank you so much to Alessandro De Maiuta, the Associazione Diplomatici, and the Università Europea di Roma for graciously hosting this event and for having me as a moderator. It was fun and was extremely instructive to have this conversation with you. I'm not sure, Alessandro, whether you want to conclude with few remarks. I'll give the floor to you. Thank you so much.
Thank you very much. No, I have no remarks. I really found this seminar very interesting because it was not the normal news that we're all able to access, and I think it's the way we do. We try to do education in Associazioni Diplomatici. We really try to give controversials way of thinking to the students, and seeing the questions, I think that came out. I want to thank everyone who's participated, Mattia Ferraresi, especially you for moderating this debate. It is an utmost pleasure and honor, obviously, to have you here. And from our side, we are really open, and we were thinking with Aniello to schedule a bit of these meetings throughout the year with the students that we have, and maybe involve you in all the activities that we organize around the world. For this, in a couple of weeks, the students in a couple of weeks. In a week, the students will be coming to New York City. We are going to be meeting there. We're going to have more than 3,200 students coming from 114 different nations. We really try to pass on, and I think this came out from this webinar, an idea of freedom, an idea of liberty, an idea of law to these students. And every time we interact with these students, we know that the future is good. We have a positive view on the future. Unfortunately, I do not have a very positive view for the near future, but I know that once this generation, these students that are doing these activities, that are in Università Europea, that are doing all these things, are going to be the leading class. I think we can be ready to have a beautiful future. I think you described very well the complication of the United Nations. You described very well, all of you, the complication and the egoism behind the decisions of certain countries, especially in the conflict with Ukraine. It's going to be their task. They'll be pretending of being ambassadors of the UN. So I think they're going to find this very instructive. Thank you very much to Adelaide Luminari. Thank you very much to Professor Guido Trafficante, and especially thank you to Professor Aniello Merone, because he was the mastermind along with Giusy and our team behind these flat seminars.
Since I received a lot of thanks, let me thank really to the other speakers, to Adelaide, Guido, and to Mattia in particular for his moderation. That was really fantastic, I have to say, and he showed with us all his competences. He was really keen and with a lot of competence about international relations that it focused from here. So I really consider a privilege have him here, and also for the students. I invited them to follow what Mattia Ferraresi used to write about international relations, because he's a very, very good writer.
Indeed.
Thank you so much. Thank you.
Thank you very much, everyone. Have a lovely day.
Thank
Bye.
you. Bye. Bye. Thank you.